We start first with the limitation period, which is recommended to be 1 year. We accept that, and moving from the James I statute of 1623 for 6 years. Usually, a libel has been committed and 6 years have passed, and by the time you get to trial, many other years, you only bring it back to the fore. So we think that 1 year is a reasonable time, and we accept that proposition. Now, we come that was recommended in recommendation 2. Now, we have, Madam Chairman and members, recommendation 5, offer of amends, and then we go to apology at 6, and then we have at 8, a declaratory offer, a correction offer at 9, and we go over to triviality as recommendation 4. Now, it seems to me that what the committee was endeavoring to do under these various recommendations is to come up with some procedures whereby you could dispose of very quickly libel actions instead of having them drawn out before juries and costs and appeals. Now, on the triviality, I find that what has happened here is that we submit that what should be done is that we should try and have what has been recommended in the United Kingdom under their Defamation Act Section 8 and also their rules of court to have summary trials. The judge in the first instance can deal with the matter summarily. You can ask to be struck out, or you can go and ask for a summary trial, particularly where the damages the judge feels will be minimal and the publication has been minimal. He can give a summary judgment, and that will put an end to the matter rather than going on. We have a problem with that in that our rules of court, Present Rules 2002, has a provision for summary trials except, and one of the exceptions is defamation. You cannot get a summary trial in Jamaica on defamation. And then you have Section 45 of the Supreme Court Judicature Act, which calls for jury trials in defamation matters, and the Jury Act, Section 26. So if we wanted to have summary trials, then we probably have to amend that. I must bring it to your attention that we have had 2 decisions of the Supreme Court. I can't refer to them now because they are an opinion. I don't want to say who the parties are. But 2 Jamaican judges have already started to apply the summary trials, and in one case they struck out the action on the condition that the defendant apologized, which he did not. And both of them are now before the Court of Appeal because the issue is that we have not yet adopted the English statutes or the English rules of court, but the judges apparently on the White Book have applied those to 2 cases. Now, it seems to me that if we could have a summary trials, a summary judgment, then we could eliminate having offer against declaratory judgment, apologies and that, and try and truncate them under one head under the summary procedure. Because it seems to me that when you have offer of amends, it's the same type of thing you're trying to get at. A triviality, correction order, declaratory order. All those seem to me could come under one thing. They dealt with under summary judgment. Or striking out. The judge has 2. You can make 2 applications. One to strike out being frivolous and vexatious, or showing no cause of action, or you can go for summary judgment if the damages you think are not high, or if the publication has been very limited. So, whilst we agree with the small committee in coming up with these things, I have gone a little further and say I think you could put them under one umbrella. That is a submission that I would think would be favorable. With the apology, I have a slight difference in the apology because usually, as it points out, the apology is not really saying that you have no defense or is not taking an additional liability, but usually goes to mitigation of damages. In the question of considering damages, one of the issues is why didn't you apologize? Or you had an opportunity, you refused to apologize, and therefore it tends to increase and inflate the damages. So apologize, or not really defense, usually goes to the assessment of damages, and we agree with what is the recommendation there. As far as justification is concerned, Madam Chairman and members, we have no objection to what is really a semantic change, and that is justification for truth. Because in legal parlance, you will have to prove the justification or the truth, whichever umbrella you put it under. The burden will be on the defendant to prove that what he has said is true. Not in every aspect of it, but what is known as the sting of the publication. You have got to prove every statement you make, but once you prove the sting, that should be sufficient to satisfy the truth. Now, when we come to innocent defamation, this again is another innocent dissemination. This again is another area where we accept that there should be a defense of innocent dissemination, whereas they have put in the appendix the Australian position. We will also bring to attention of the House the Section 1 of the United Kingdom Act, and later on I will tie that up with what is known internet publications, the use of the innocent dissemination. We have put the small committee has put the appendix there, but we have also taken exception to certain aspects of it, where it says that the defendant neither knew or reason to have known that the matter was defamatory, and the defendant's lack of knowledge was not due to any negligence on part of the defendant. We think that it's difficult, because if you're going to use innocent dissemination, it means you disseminated the thing without any knowledge of what was done. I'll come later on to a case where you can see where, when facts are brought to your attention, that you are warned and say, look, we are going to complain about these things because it's defamatory. Then if you go ahead and publish it, then certainly you have a problem, and that will become done in the internet situations. But bar that, we think that this is a little bit too wide, and we prefer the English Section 1 of the English Act of 1996. Now, if I may move on to the question of the role of the jury. Now, the small committee at recommendation 10 at page 25 of the report says that the role of the jury is to find whether the defamatory matter was published by the defendant and whether any defense has been proven, and that the judge to be assessed the amount of compensation that we awarded. Now, first of all, dealing with the question of the amount of damages that is to be awarded. And what we find is that it has been shown that the jury has demonstrated that they are incapable of making reasonable awards. All the awards made by juries, most of them have been found to be manifestly excessive and have had to be reduced by the Court of Appeal. Not only in Jamaica, but the same thing is in England.